Welcome back to Enterprise Unleashed, business law and innovation with experienced business strategist and trial attorney Richard P. Corey, nicknamed the Closer. Richard prides himself on striving to maximize his clients' desired outcomes in both transactional and litigation settings. I'm Evan Mack, and today we're talking about planning your exit. Whether you're preparing to sell, merge, or maybe expand under new leadership, the goal is the same: to retain control, protect value, and leave on your terms. Richard, my man, welcome back.
What's up, Evan? How are you, man? Good to see you.
I'm well, sir. Listen, Rich, like it's why is it essential to start thinking about that as exit strategy long before business is actually ready to sell? Like in your experience, especially building something for about 12 or 13 years.
Well, exit value starts beginning to be built years before the sale. You're like, the sooner founders start thinking about the finish line, like ultimately where they're trying to go, the more intentional their decisions become regarding the structure, the tax strategy, your record keeping, your staffing, your intellectual property protection. Like, great exits happen by design, not by accident. So these are things that you want to put a structure in place for your exit as soon as you get the ball rolling, because how you start is going to dictate how you finish. So you need to have, it's good practice to be thinking of your exit and crossing your T's and dotting your I's. That sounds so cliche, but really putting in the proper protocols and operational provisions in everything that your business is doing right from the jump. Because if not, you're going to have to go back and clean that up, and that's going to be very inefficient and ineffective. And also, your potential buyers, if that's what it is, if it's kind of a sale, they're going to see that. They're going to see it on your books, because you can't hide it unless you're going to be dishonest.
What are the first legal and financial indicators that tell you a company is prepared or maybe not prepared for that potential acquisition?
Just like how I just said, dude, like, first thing you do is take a look at their books. Are their books in order? Their books are a mess. That tells you that they're financially sloppy. So then it's, that your due diligence from the buyer side is going to require some deeper look. You're going to have to look under the hood a little bit further, because you want to know exactly what you're buying. From the seller standpoint, you want to be able to show, like, this is what you're getting, this is how we run the business, and this is why you're going to pay this amount of dollars for it. It'll justify your asking price. You want to have organized contracts. So everything from your operating agreements to your employment contracts to your customer contracts, your vendor contracts. You want to be able to go to a potential buyer and say, look, we have these vendors, we have these agreements, this is our lease, this is, these are all these categories of documents that are well organized. We could tell you who, what, when, where, and why at any time. And again, that increases the value of what you're selling. I was going to say another thing too is make sure you document your IP, your intellectual property. So if you have any kind of trade secrets or copyrights, make sure they're registered. If you have trademarks, register your trademarks. These are things that are not, all things considered, they're not very expensive to do, and they add significant value to the value of your business. Another main thing too is make sure if you have any litigation or pending litigation or threatened litigation, get rid of it. Get it off the books. You don't want that. A buyer is going to see that and run. So the best thing to do is, if you have, even a lot of times businesses, it's par for the course. You end up with contract disputes, payment disputes, even customer disputes. As much as you try to please everybody, especially people that are in like service industries, like landscapers, HVAC companies, retail companies, online sales, make sure that you have no pending issues. Like if you have some small claim stuff, settle it, get it off the books. I mean, I have a lot of clients where they're not wrong. Let's say there's somebody brings a legal dispute, and they're like, no, we're right, they're wrong. But it doesn't pay to be right. You're cutting your nose to spite your face. You're trying to sell your business, and you have an active complaint. Get rid of this guy. Pay him. Well, I don't want to pay him. They didn't do their job. Well, you know what? First of all, the cost associated with me defending this lawsuit exceeds the amount that we could settle it for. So that's dumb. That's not the most intelligent way to say it, but let's be honest.
Well, yeah, that's just your pride. Their pride's getting in the way, though, of the bigger picture.
But pride is a car. That's one of the 7 deadly sins, especially when you're trying to sell your business. If we're talking about an exit, the litigation, no matter how big or small, is still going to be a red flag on how you operate your business. And again, a buyer, whether it's either if they're looking at your, they're doing their due diligence, they're going to be looking at the potential litigation or active litigation, no matter how big or small, as a reflection of what they're purchasing. So if they don't want to be buying a problem.
So Rich, what about poor record keeping? How or missing documentation? How does that impact valuation or kill a deal before things get started?
Well, I feel like the answer to that is inherent into the question. I mean, buyers are not going to buy uncertainty. If the financials are inaccurate, if contracts are missing, if the ownership histories aren't documented, that deal is either going to collapse or the valuation is going to plummet. You're going to drive the cost of your business downward unnecessarily. And I see this happen all the time. So whenever I'm working with a company or working with the partners that are of a company that are getting ready to present for a sale, or they're scaling up, or they're looking for an exit, we need to make sure that all of this is in line. And you got to really look at things, because a smart forensic accountant will pick up on BS right away. And if you're talking about, like a 2 or 3x, or sometimes, 10x EBITDA, which are some of these companies are they're selling for. If you're expecting to get that kind of a sale price, then you better expect that the buyer is going to be doing their due diligence and make sure that it's worth that amount of money.
So what's the difference between selling a company's assets and selling its ownership interest? How does that affect the liability for the seller?
Oh, that's a really good question. So from a seller's perspective, if you can do a stock sale, which comes with the assets of the company too, but then the buyer assumes all the liability. From a buyer's perspective, you want to buy the assets. You don't want to buy the stock, because if you just buy the assets, so let's say the equipment, the customer contracts, the customer list, the intellectual property, you buy it and you're taking it into your own company. Whatever assets whatever liabilities, any obligations, debts, those stay with the buyer. With the seller, excuse me, they stay with the seller company. If you're only buying their assets, like if somebody comes in and buys the computers, the customer list, but they don't buy the stock, whatever problems that the seller company had stays with them. So from a buying perspective, asset purchase makes more sense. There's other things to take into consideration too, like tax decisions and things like that. But the best from a buyer standpoint, the best way to insulate yourself from liability is buy assets and make sure that they're unencumbered. If there's personal guarantees, like example, if you're buying the stock of a company and even on a lease, there's typically going to be a personal guarantee on a lease. If you are inheriting that, the landlord may require you as the buyer to substitute as a personal guarantor of that lease when you may not need to. So there's a lot of things to take into consideration. From a seller standpoint, you want to get rid of the stock. From a buyer standpoint, you only want the assets. That's not 100% all. It's not black and white, but it's pretty black and white.
So Richard, when negotiating a sale, what contract provisions most often determine whether the seller keeps control of the outcome?
Well, there's a lot of things that come into play in any kind of sale, whether it's a stock sale or an asset purchase. You're going to have representations and warranties of both the buyer and the seller. So if let's say I represent the buyer, I want to look at the representations and warranties of the seller. Where, example, if the seller is saying that our assets are unencumbered, there's no like UCC ones on it, we don't owe any, there's no debts, there's no pending lawsuits, there's no employment disputes. So we want to have them represent this, and that will become a material term of the purchase agreement, whether it's stock or an asset purchase. And to the extent those are breached, we can have protections built in, like where there is a clawback of the purchase price, where they forfeit the remainder. Like if it's financed, someone forfeits the remainder of the purchase price because they were dishonest. So there's a lot of protections that put in play, but representations and warranties from both sides are always important. Then the next thing, this leads into indemnification provisions, where again, if I'm representing a buyer and the seller gives all these representations and warranties, like if my contracts are all good, they're in good standing, I'm not in material breach of any of my contracts, I have this customer base, I have rights to use this intellectual property. If something happens and that's not true, and then you get sued, or you have you have to come up with a payment to a third party that you didn't expect because the seller was dishonest, you put in what's called an indemnification provision, where when that happens, the person who breached the representation warranty has to pay, not only pay for the liability, but for the cost, including attorney's fees associated with it. Then you also have post-closing covenants. So after closing, you want to make sure that people are not going to do things to jeopardize the business or the sale. So here's a silly example, but let's say you're buying a hair salon, and it's like, well, they have this customer base, this client base, but if the barber or the hairstylist that's been there for however many years that everyone goes to opens up shop right down the street, all the clients are going to go with them. So you want to have, I mean, that's a simple example, but you want to make sure that you're not going to just buy an empty shell and it's going to be water like just flowing through your hands. That's not, you want to make sure that there's it's called a post-closing covenant. So it's structured specifically to each, it's tailored specifically to each transaction, but things to make sure, like non-competes, where you don't want, again, somebody opening up down the street or and then taking all their customers. Or if it's like a doctor's office, you buy the assets of a dental practice, then that dentist goes and just opens up shop down the street, and all the patients that have been with that dentist for years, you just bought the company, but you have no patients now. They all went back. So you want to make sure that there's fair and reasonable covenants, but there needs to be some kind of protections to secure your investment, into the company. Or if let's say I'm selling to someone and I want to look out for my staff. I want to make sure that my staff is going to, like, if I'm leaving, let's say I'm retiring, but my staff, I don't want them to all just be out of a job. I want to make sure that they are given the same key positions at the same salary, or if not better, if I can negotiate, that they were currently getting. So there's a lot of things that go into it, but really it's the representations and warranties, indemnification provisions, and then post-closing covenants are three categories of contractual terms that need to be really taken into consideration.
You talked about the non-compete a little bit, but how should business owners approach that non-compete or the earn-out clauses so they don't undermine the value they've worked to build?
Well, they need to be reasonable. Non-competes need to be reasonable in both time and scope. If you try to, you can't make it a complete ban on trade. But if somebody's selling a business, or if you're hiring somebody, you want to have fair and reasonable terms, because you have to protect what's called legitimate business interests. So you don't want somebody going and soliciting your employees, or after they sell you the business and then I go and take your employees because they worked for me beforehand, or soliciting your vendors, your customers. Like Evan, you buy my business, but then I sell it to you. We signed a contract, but now I'm calling all your customers and saying, hey, come with me. I just opened up down the street.
Yeah.
You're SOL. So but if the non-compete is overly broad, if it is too strict, if it's it's too long, or it's too large in geographic scope, meaning like if it's a prohibition on 20 miles, where a reasonable restriction would only be like 2 or 3 miles, it won't be enforceable. Now, there's actually Florida statutes on this that govern it. Like, I'm in the state of Florida. I don't know how it is nationwide, but typically every state has some kind of non-compete statute where it says, okay, like if it's an asset purchase, then this amount of time is considered reasonable. This amount of time is considered per se unreasonable. So you got to stick in between. I always try to make it as fair and reasonable as possible, because you want to negotiate a fair deal. It needs to be good for everybody, and that's the best way to do business. I think that's good business practice, and it facilitates just a streamlined process, and it minimizes the likelihood of litigation in the future.
So, Richard, what does an effective due diligence look like from the seller side? How can it prevent surprises late in that process?
You want to organize your financials. You collecting all your contracts. You got to verify your IP ownership. Again, if you have any disputes, we talked about this a little earlier. If there's any litigation or pending disputes, if there's issues with employment disputes, are a big one. You want to make sure that you're current with your landlord if you have a landlord, updating all your employment records, and then ensuring compliance with everything. So you want to make sure that all of these categories of contracts and potential problems, are presented in such a way that not only are they accurate, but they're attractive. If you have a pending litigation or a long litigation history, that's going to be a major red flag in the viability of somebody purchasing your business, or even worse, on the purchase price. So, like I'll come in and let's say if I'm representing a seller and these people and the buyer has a lot of active litigation, then that gives me negotiating leverage to lower the price. Now, it's not like an aggressive tactic or like a switch tactic, but it's the reality of the situation. Like, look, you're in the middle of 3 lawsuits. So,
Mhm.
we're coming in and we're going to buy this business from you. We're inheriting that litigation. So like that's now, your asking price of X isn't worth X, because it's going to cost us Y to fix your problem. So now what we're willing to pay is that. And,
Mm.
you do some negotiating, but if you clear those off your books before the sale, then those problems don't exist. So if I'm representing the seller, that's the first thing we try to do is, one, make sure all your financials are accurate. That's the first thing you need to do. Do not present false statements. That's a good way to not only blow the deal, but they end up in jail.
Mhm.
So you don't want to do that. And at my office, we don't sacrifice our integrity for anybody. Um,
Absolutely.
but then if they have active litigation, do the best you can to get it to be done with it. Otherwise,
Mm.
it's a huge deterrent on the potential sale, because even if the amount in controversy isn't that significant, the cost associated with litigation is out. It's astronomical, and people don't realize whether there's $10,000 in dispute or $10 million in dispute. The litigation, the process of drafting a complaint and going through discovery, depositions, it's the same no matter what. So I've seen people spend $150,000 on litigation over $20,000 in controversy.
Wow. Wow.
And if there's an attorney's fee provision in that contract, it now becomes a case about attorney's fees, and it doesn't even matter what the original issue was. It's now everyone's fighting to get their fees back because they're so deep in the hole. There's no turning back.
So, Rich, to close things out for anyone considering an exit in the next few years, what single strategic step can they take today to strengthen that position when that moment arrives?
Well, I would start treating your business as if you're going to be audited tomorrow. When you do that, if God forbid you do get an audit, you trigger an audit from like the IRS or something. Like example, my business, they can come in and take a look at any time they want. It's a clear operation with my clients. It's always transparency, like very clear. Like there's no tricks, there's no hidden fees, nothing like that. But yeah, if you start treating your business as if you're being audited tomorrow, then you'll be forcing yourself to run good business practices and operations. Your protocols will be efficient, they'll be accurate, and also that'll help you. That'll save you time and money when you don't realize. And I went through this when I was growing my business. I was spending a ton of money on stuff that I didn't even realize I was spending. You have $20 a month for this subscription, or $100 a month for this subscription, for Adobe, for like things that are business expenses, but I have 2 subscriptions for the same thing. Like I don't like
Right.
it's just inefficient and that is it's sloppy business. So if you treat it as if you're getting audited tomorrow, then you'll force yourself to stay in compliance throughout your business. And then when it does come time for that exit, you're ready to go.
All right. Richard, I appreciate you, brother.
Yes, sir. As always, man. I hope you have a happy Thanksgiving too.
You too, man. You too. I know you got some business to handle, but hope you can get a little bit of time,
We're getting ready for trial over here, so we got a lot of work to do, but I'm looking forward to some turkey.
Absolutely. That's it for today's episode of Enterprise Unleashed Business Law and Innovation with my man, Richard P. Corey. To connect with Richard, visit rcenterpriselaw.com. Don't forget to like, leave a review, and subscribe to the show for more conversations on strategy, law, and innovation. Thank you so much, guys. We'll see you next time.
Yes, sir.